What is the history of environmental law? Have you ever wondered how we got to the point where environmental law is such a vital part of our legal system? The history of environmental law is a fascinating journey that spans over a century. It all began with early conservation efforts and common law principles. Initially, issues like pollution and resource depletion were addressed through basic legal concepts such as negligence and nuisance. These early methods offered limited solutions for the growing environmental challenges. In the early 20th century, legislation started to focus on the conservation of specific resources. A significant milestone was the creation of the National Park Service in 1916, which aimed to protect natural landscapes. Another important law was the Migratory Bird Treaty Act of 1918, which provided protection for migratory birds. These early laws laid the groundwork for a more structured approach to environmental protection. The modern era of environmental law took shape in the 1960s and 1970s. This shift was largely driven by rising public awareness of environmental issues. A key moment was the publication of Rachel Carson's book, Silent Spring, in 1962. This book raised concerns about pesticide use and its impact on health and the environment. It sparked a movement that led to significant legislative changes. During this period, several foundational federal laws were enacted. The Clean Air Act was first passed in 1963 and underwent major amendments in 1970. The Clean Water Act followed in 1972, and the Endangered Species Act was established in 1973. These laws created regulatory frameworks to control pollution and protect endangered species. Another landmark was the National Environmental Policy Act of 1969. This law requires federal agencies to assess the environmental impact of their projects, ensuring that environmental considerations are part of government decision-making. The establishment of the Environmental Protection Agency in 1970 centralized federal authority over environmental regulations. As the years progressed, additional laws emerged to address specific issues. The Resource Conservation and Recovery Act of 1976 focused on hazardous waste management. The Comprehensive Environmental Response, Compensation, and Liability Act, commonly known as Superfund, was enacted in 1980 to clean up contaminated sites. Today, environmental law is a broad field that intersects with many areas, including administrative, corporate, and international law. It addresses a wide range of issues, from pollution control to climate change and sustainable development. Legal professionals in this field have diverse career opportunities. They can work in government agencies, private law firms, advocacy organizations, or international bodies. For law students interested in public interest law careers, environmental law offers a chance to tackle pressing issues like climate change law. This area focuses on using legal tools to combat global warming, promote renewable energy, and ensure environmental justice. Understanding the history of environmental law is essential for grasping the current challenges and the role of lawyers in shaping environmental policy.